Hello, my name is Galina Kurdina. I live in Toronto, Ontario, Canada. Today I would like to talk to you about Canadian justice. Canadian justice in all its beauty. Subject of our conversation will be very simple: bedbug infestation of a building where I lived in 2010, from 2010 till 2019. And we will discuss a court case where justice concocted all her arguments and after that made a conclusion based on these concocted arguments. I repeat one more time, it's not a case where justice failed to give enough weight to solid argument or ignored solid argument. No, nothing like that. This is case where justice concocted, invented all arguments, concocted arguments, contradicted all arguments by both sides that were submitted to her, and made her conclusion. After that, all appeal courts like Divisional Court, Court of Appeal for Ontario, Supreme Court of Canada, all them supported her position. So I would like to read some excerpts from my court documents. Ms. Galina Kurdina was the plaintiff in an action brought to the Landlord and Tenant Board Ltd for negligence of her former landlord, Toronto Community Housing Corporation, or TCHC, on the 4th of October 2018. TCHC is wholly owned by the City of Toronto, so Ms. Kurdina actually sued the Canadian government at the municipal level for their negligence. The initial claim was filed by the petitioner for an order compensating her expenses because of severe bedbug infestation in the multi-story building at 50 Tuxedo Court, Scarborough, Ontario, Canada, where she lived in Unit 601 in 2010-2019. Bedbug infestation was a terrible problem in this building, including the 6th floor where the petitioner lived. She experienced it from the first year of living in the building. She had to buy a lot of anti-bedbug sprays and powders and treated her unit by herself until 2016 year. In 2016, this problem turned into an every night terror. Continuous stream of parasites started entering her unit. At the LTB hearing and during the review and appeal processes, nobody objected the fact that contamination of the building was awful in 2017-2018. Nobody objected the applicant's claims in her initial complaint. At the board hearing and during the review and appeal processes, that such awful infestation demanded timely and efficient treatment of every unit in the building. Infestation was so awful that every unit in this building had to be treated in order to get rid of parasites. At the end of 2016, the petitioner informed the superintendent about this problem and asked him to inspect and treat every unit in the building, since sources of infestation were other apartments, not her. The petitioner survived 16 treatments of her unit by different professional teams in 2017-2018 years, in addition to her own endless treatments during endless sleepless nights. Professionals from different pest control companies said to the petitioner that they found live bed bugs and their marks in her apartment. Despite these 16 treatments of the petitioner's unit, nothing changed for her till the end of 2018, since the landlord didn't want to inspect and treat every unit in the building. The landlord treated only few apartments where tenants admitted bedbug infestation or TCHC found live bedbugs in the daytime. The petitioner had to spend a lot of time and energy to partially or fully prepare her apartment many times in 2017-2018. Full preparation of a unit for treatment means that a tenant must empty all pieces of furniture, clean and move them 40-60 centimeters from walls, wash and dry all clothes, clean all items, floors and carpets. Partial preparation means that the tenant must do all these manipulations in a part of the apartment. All full and partial preparations that the petitioner made in 2017-2018, all treatments by professional crews, all her own treatments, caulking of baseboards were not helpful. They were absolutely useless, made in vain, and additional torture for the petitioner, since her unit wasn't the source of infestation and parasites came back to her apartment every time after treatments. The petition filed a complaint with LTB on the 4th of October 2018. At the end of October 2018, the worst wave of bedbug infestation happened in her unit. In her request to review the initial LTB order, the petitioner submitted 3 original photos of dead bedbugs, which she collected during this last and most terrible wave of infestation. These original photos were clear images of bedbugs, were attached to an email with the request to review. Miss Cordina bought many anti-bedbug sprays and powders, treated the unit by herself, had to throw her 2 small lovely dark blue sofas away since they were heavily infested, and buy 1 new white day bed with white mattresses from IKEA on the 7th of November 2018. Her own treatment and this purchase helped end the cleaning of her apartment from bedbugs. The every night terror of awful bedbug infestation lasted for Galina Kurdina more than 2 years. This is a little bit about bedbug infestation, and now about court hearings and their rulings, and these were all magic stats. The initial claim was filed with the Landlord and Tenant Board by the petitioner in October 2018. On the 4th of December 2019, the Vice Chair of the LTB, Ruth Carey, released an order that dismissed the petitioner's claim, initial order. Ms. Galina Kurdina requested to review the initial order in December 2019. On the 26th of March 2020, Vice Chair of LTB Kevin Lundy released an order that denied the request to review the initial review order. Ms. Galina Kurdina appealed from these rulings with the Divisional Court for Ontario in November 2020. On the 22nd of January 2021, Honorable Justices Swinton, McCarthy, and Christensen of the Divisional Court issued a judgment that dismissed the appeal, the judgment. Ms. Galina Kurdina filed a motion for leave to appeal with the Court of Appeal for Ontario in February 2021. On the 1st of June 2021, Court of Appeal registered a decision made by Honorable Justices Strathy, Feldman, and Sosin, who dismissed the motion, but didn't provide any reasons for it, the decision. And Ms. Kurdina sought a leave to appeal this decision and sent all necessary materials to the Supreme Court of Canada. The Supreme Court acknowledged receipt of them on 10th of August 2021, however, registered the application for leave to appeal and assigned a file number to it on the 30th of December 2021, almost 6 months later. On the 28th of April 2022, Supreme Court of Canada dismissed the application for leave to appeal without any reasons for this decision. This is regarding all history, how I filed the initial claim, and after that how I filed appeal claims, and so on. So the petitioner will discuss in this petition mostly the initial order issued by Justice Ruth Carey in Landlord and Tenant Board. All conclusions made by Vice Chair Ruth Carey in the initial order were supported by Vice Chair Lundy in the review order and in the judgment of the Divisional Court. Thus, all the petitioner's arguments made with regard to the initial order will be applicable to all these rulings. Sorry for my forced speech, I cannot pronounce words normally. The petitioner would like to discuss the LTB hearing that took place in Scarborough, Ontario, Canada on the 21st of June 2019. So we will focus mostly on the initial hearing that took place in June 2019 in Landlord and Tenant Board in Scarborough. At the hearing, the board admitted that there was a bedbug infestation in the petitioner's building at 50 Tuxedo Court in the period under adjudication between October 4th, 2017 until October 4th, 2018. Nobody objected the petitioner's claims in her initial complaint, and at the board hearing that infestation of the building was heavy. Nobody objected the applicant's claims in her initial complaint and at the board hearing that such awful infestation demanded timely and efficient treatment of every unit in the building. The petitioner and a witness for Landlord, technician Tabitha Lantain, testified at the LTB hearing. Documentary evidence was submitted to Justice Carey as well. The petitioner handed to Vice Chair receipts from IKEA for purchase of a new white day bed with white mattresses on the 7th of November 2018, evidence 12, and receipts of purchase of anti-bedbug sprays and powders in 2018. The landlord brought 7 reports from 2 pest control companies that treated only 30 units in the building at 50 Tuxedo Court, Scarborough in February-September 2018. Other reports that were not beneficial for the landlord were just missed by them. For example, the landlord didn't present its own pest control inspection and treatment record about live bedbug activity found around sofa in the petitioner's unit dated the 4th of July 2018. The petitioner emphasized that at the LTB hearing that Tabitha Lantain, the witness for the landlord, started working in the building at 50 Tuxedo Court just 2 months before the board hearing on the 21st of June 2019, sometime in April 2019. And Ms. Lantain testified that 5 years prior to taking a position in the building, she worked somewhere in the environmental health, but she didn't testify that she worked for TCHC, for company that owned this building. However, it doesn't matter, since the most important thing is that Tabitha Lantain didn't work in the building in 2017-2018 period of time which was considered in this court case. The landlord brought Miss Lantain as a witness instead of a previous superintendent and professional technicians who actually came to the petitioner's unit, saw the bedbug infestation and treated it in 2017-2018. The petitioner informed Vice Chair Carey that she never saw Tabitha or talked to her in 2017-2018. Justice Carey should have asked questions about Tabitha Lantain's role in the treatment of the building in 2018 when she wasn't working there, but Vice Chair Carey chose not to ask any questions on this matter. She wasn't embarrassed by the fact that Miss Lantain didn't work in the building in 2017-2018, was unable and had no right to testify about its treatment in that period, and accepted her as a credible witness. Just a moment. Tabitha Lantain testified that she inspected the petitioner's apartment and saw perfectly white and clean bed without any live bed bugs and their signs in July 2018. For example, in paragraph 60 on page 48 of the transcript, Miss Lantain, I didn't observe any bed bugs. In fact, everything in the unit is white, so if there was any bed bugs in there, there would be fecal matter somewhere. Next, Miss Kurdina, did you find any signs of bed bugs? Miss Lantain, no, I didn't. Miss Kurdina, for example, their excrements. Miss Lantain, no, nothing. In paragraph 100 on page 57, Miss Kurdina, do you remember that my sofa beds were very dark blue? Miss Lantain, no. Ma'am, they were white. Everything, in fact, in your unit was immaculate. Everything was white. The curtains were white. Carpets were white. Furthermore, Tabitha testified that the unit was never infested in paragraph 68 on pages 49 and 50. Miss Odette, this is Miss Odette, was a lawyer for TCHC, opposite side. Okay, and to your knowledge, was unit 601 at 50 Tuxedo Court ever highly infected? Miss Lantain, no, I believe it was never infested. Miss Kurdina, she works for 2 months. At the LTB hearing, the petitioner handed over to Justice Carey receipts from IKEA, which showed that she purchased the white day bed with white mattresses on the 7th of November 2018. Prior to November 2018, she had 2 small dark blue sofas with live bed bugs and their marks on them. Technician Lantain intentionally lied, as she obviously didn't come to the apartment in July 2018 when there were 2 dark blue infested sofas. She came to the unit for the first time in the petitioner's absence no earlier than on the 7th of November 2018, after Miss Kurdina threw away her heavily contaminated sofas and bought the new white day bed, which helped end treatment of the apartment. It is clear that it is impossible to confuse 2 small dark blue sofas and 1 white day bed. The petitioner told everybody in the courtroom about inconsistencies between Tabitha's testimonies and what happened in reality at least twice, and claimed at least 4 times that Miss Lantain didn't tell the truth. For example, on page 68 of the transcript, Miss Kurdina, I just don't know what to say because a lot of people, tens of people, superintendent, crews of professionals came to my place and testified they saw the signs of excrements, of bed bugs. Now, instead of these professionals who actually saw this problem, they brought this technician who has worked for 2 months and never ever saw my apartment before, and she testified something absolutely untrue. It means that Vice Chair Carey perfectly understood that Miss Lantain didn't come to the petitioner's place in July 2018. This was impossible, and Tabitha could not be qualified as a credible witness in this matter, whether the apartment was clean of bed bugs or not. Justice Carey disregarded all these proofs of Tabitha's willful and intentional misrepresentation and accepted Tabitha as the credible witness and her testimony as the compelling evidence. This finding of Tabitha as the credible witness was unreasonable in light of all the evidence. Finally, Tabitha Lantain testified that the treatment of the entire building, including the petitioner's heavily infested unit, was completed in July 2018. Then she contradicted herself and testified that the treatment of the entire building was still progress. Treatment of several units in the entire building was still in progress in September 2018. There were many other contradictions and discrepancies in her testimony as well. Ms. Kurdina would like to remind that according to the order of Justice Ruth Carey, there were 3 issues before the Landlord and Tenant Board. First, did the rental unit or residential complex have a bed bug infestation during the period over which the board has jurisdiction? Second, if so, did the landlord address the infestation in a timely and effective manner? And third, if the landlord didn't address the issue in timely and effective manner, what remedy should flow to the tenant? It was test that I don't know, maybe it was invented by Justice Ruth Carey, I don't know, but she applied this test to this court case. So the first issue was proven at the hearing. It was proved that the residential complex had the bedbug infestation during the period over which the board had jurisdiction. Justice Carey stated that issue of the petitioner's infestation didn't really matter for her, since the first issue does not demand proof of the rental unit infestation. Proof of infestation in the residential complex is enough to move to the second issue. The problem of infestation of the unit could have been considered later at the third issue, at the third step. Anyway, Ms. Kordina provided solid evidences of infestation of her unit at the LTB hearing. Her testimony, receipts from Canadian Tire, receipts from IKEA, and so on. And plus, Justice Carey received 7 reports from the landlord about treatments of the unit in 2018 without any notes that the treatments were preventative, and with notes that the adjacent unit 626 was heavily infested. There was a note in the report of the pest control company that it is possible that she is getting bed bugs from unit 626. There are notes in these reports that another adjacent unit, 602, was treated for bed bugs as well. However, the landlord and tenant board held that the petitioner failed to prove on a balance of probabilities that her unit had been infested. The point is that this LTB conclusion, based on the reports from the landlord and testimony of Tabitha Lantain, was incorrect, since evidence against infestation of the petitioner's apartment wasn't solid. First, Vice Chair based the finding that the petitioner may not have had an infestation inside her unit on her own misrepresentation of negligent and incomplete records of the landlord about absence of live bed bugs in the unit in the daytime. Not finding bed bugs in the daytime does not at all mean their absence in the unit, since these parasites are nocturnal animals and hide deeply in furniture, cracks and crevices in the daytime. It is practically impossible to find them in the daytime unless infestation of a unit is extremely heavy. Moreover, these pest control records do not indicate that apartment was clean of bed bugs. The records do not indicate that the unit was clean of their signs as well. The records do not specify that treatments of the unit were preventative. Second, Vice Chair Carey made the finding that the petitioner may not have had an infestation inside her unit based on proven lie of a non-credible witness, Tabitha Lantain, that petitioner's unit was never infested. She lied that as if she saw perfectly white and clean day bed instead of 2 dark blue small sofas that were in my apartment in July 2018. Therefore, Justice Carey's finding that the petitioner may not have had an infestation inside her unit was unreasonable in light of the evidence. At the LTB hearing, the petitioner informed Justice Carey that she had a container with dead bed bugs. She collected the parasites inside her apartment during 2017-2018, showing the container to technicians who came to treat her unit and emptying the container after each treatment. Ms. Kordina wanted but didn't bring the container to the hearing. The main reason of it was the petitioner's disability. Her memory is seriously damaged. The petitioner prepared the container but forgot it at home. The petitioner said to Justice Carey about her disability at the hearing. If LTB had demanded to provide evidence in advance, the petitioner would have sent photos of the container with bedbugs to the landlord and the board before the LTB hearing for sure. However, LTB prohibited parties from doing this in 2019, and parties had to exchange their evidence at the LTB hearings. Thus, LTB discriminated disabled self-represented people and put them in difficult situation when they just didn't know what they had to bring, could forget to bring something, had no idea what they had to contest at board hearings, were not prepared for willful misrepresentation of other side. This was breach of procedural fairness in LTB rules in respect to disabled self-represented people, and one of the causes of what happened at the LTB hearing and the board's unfair decision. So LTB, this is very interesting point, that LTB rules prohibited parties from exchanging of their evidence before hearing. I was reprimanded by Justice Ruth Carey for providing some part of my evidence in advance. She very loudly and rudely reprimanded me. It was exclusive fault of LTB that the petitioner was unable to present this container. Their inadequate and unfair rules in 2019 that prohibited parties from exchanging evidence in advance before hearings, and refusal of LTB Vice Chair Kevin Lundy to accept photos of the container which Ms. Kurdina sent to him with a request to review the initial order. LTB had to accept this evidence since the petitioner forgot to bring it to the LTB hearing because of her disability. Just a moment. Next, the petitioner testified at the LTB hearing that the landlord never responded to her complaints. Now, please be very focused, because the real magic starts from this point. So once again, the petitioner testified at the LTB hearing that the landlord never responded to her complaints. Page 38 of the transcript. Ms. Odette, lawyer for the landlord. So you would agree that any time it was brought to Toronto Community Housing's attention that they took action to inspect your unit and treat where necessary. Ms. Kurdina, one more time. Every time I brought to attention of TCHC problem that our building is infected and sources of this infestation are outside of my apartment. Madam Chair, so the question, Ms. Kurdina, and there was almost, Madam Chair, ma'am, you are not answering the question. Ms. Kurdina, yes, they can. Instead of treatment of all building, they came to me every time. Madam Chair, so the answer is yes. Ms. Kurdina, yes, Madam Chair, but you wanted whole building treatment, is that right? Ms. Kurdina, yes, I wanted the whole building treatment. Madam Chair, okay, Ms. Kurdina, because treatment of my apartment didn't fix this problem. So it was clear, I made it absolutely clear to Vice Chair Ruth Carey that I demanded treatment of every apartment in our building. Unfortunately, TCHC never responded to my requests, to my complaints, and they treated just a few apartments in the building. Yes, the landlord treated the petitioner's unit, but this wasn't the request in the Ms. Kurdina's complaints, since she asked to treat every unit in the heavily contaminated building. It is clear from the excerpt that Justice Carey perfectly understood the petitioner's complaints to the landlord that they didn't treat every unit in the heavily contaminated building and her request to do it. Vice Chair Carey perfectly understood that Ms. Kurdina testified that the landlord never responded to her complaints. However, Justice Carey made a finding in her order that the petitioner testified as if the landlord had responded to her complaints. Her finding is based on no evidence. Furthermore, her finding of this fact is totally opposite to the petitioner's initial claim and her testimony at the LTB hearing. Such gross manipulation and distortion of the petition's testimony is an error of law and obvious bias in favor of the landlord. The petitioner addressed this error of law in her appeal documents, but was ignored by the divisional court. As everybody can see, Justice Carey interrupted the petitioner thrice during this short period of time, trying to prevent her from properly answering that the landlord never responded to her complaints. Justice Carey interrupted the petitioner many more times at the LTB hearing. These interferences prevented the petitioner from talking normally and violated her right to testify freely at the LTB hearing. It was an error of law and bias in favor of the landlord, since the board breached the rules of procedural fairness. Next, please be very focused, very concentrated, because this is the most important point, the most important issue. Next, the board member Justice Carey accepted the landlord's evidence that it had conducted inspections at treatments in the building from February through September 2018. For example, the witness for the landlord, technician Tabitha Lantain, testified that the landlord found live bed bugs and treated unit 626 in September 2018, paragraph 76 on page 51 of the transcript. In the landlord's report submitted to Justice Carey at the LTB hearing, live bed bugs were found and treated in units 319, 1212, and so on in August-September 2018. The landlord didn't find live parasites at the time of treatment, but treated for bed bugs units 1503, 1112, and so on in August-September 2018. The petitioner lived in one of these units, 601, treated in September 2018. Thus, 10 units were treated for bed bugs in August-September 2018. The landlord planned but had to cancel treatment for bed bugs of 3 units, 10, 12, 7, 25, 12, 23 in August-September 2018, just because they didn't have access to them. Therefore, it is obvious that the landlord had to come and treat at least these 3 units later, and the treatment of the building didn't end in September 2018. In her conclusions, Justice Carey made a finding that inspections and treatments in the building took place from February through July of 2018 based on no evidence, thus actually contradicting all evidence. Thus, she shortened time of treatment of the building in favor of the landlord in order to make it appear timely and efficient. Such manipulation with evidence in favor of the landlord is an error of law and obvious bias. The petitioner addressed this error of law in her appeal documents but was ignored by justices of the divisional court. Next, in her ruling, paragraphs 17 and 19, Justice Carey made findings that in fact the landlord's evidence establishes that every unit was treated, and between February and July of 2018, every unit in the building was inspected and treated. These conclusions are based on no evidence. Furthermore, all the testimonies and documentary evidences submitted at the LTB hearing contradict this ruling of Vice Chair Carey and support the petitioner's testimony that the landlord didn't treat every apartment in the building in 2017-2018. Please be focused, because this is the most important points in all this court case and appeals of this court case, how Justice Carey concocted her arguments. So, first of all, she concocted as if I testified that landlord responded to my every complaint when I testified that they never responded to my complaint properly. Second, she shortened period of treatment from February September to February July 2018, and now she invented, we will discuss how she invented that every unit in the building was treated. Tabitha Lantain clearly specified at the LTB hearing that what she actually meant when she was talking about treatment of the building. She testified it when she was presenting to Justice Carey the landlord's report of treatment of two apartments, 601 and 626, dated the 8th of February 2018. The petitioner realized from reading of the transcript, since she missed a lot of Tabitha's testimony at the LTB hearing, that the landlord, so the petitioner realized from the reading of the transcript, that the landlord looked for units with live bed bugs in order to treat only them. Ms. Lantain testified in paragraph 50 on page 45 of the transcript. We did do a whole treatment of every unit that needed to be treated. Ms. Lantain clarified what units, in the landlord's opinion, needed to be treated in paragraph 51 on page 46 of the transcript. If unit comes, if they find live evidence, then, but it was immediately interrupted by Justice Carey. Madam Chair, no, I mean during this period of the whole building cleanup. Justice Carey interrupted Mrs. Lantain because she didn't want Tabitha to say that the landlord treated few apartments where tenants honestly admitted bedbug infestation or TCHC found live bed bugs, since such treatment of few units in the heavily contaminated building was obviously ineffective. It apparently didn't cover all apartment sources of infection that required it in 2018. So she didn't want Tabitha Lantain to testify that TCHC treated only a few apartments in the heavily contaminated building instead of treatment of every apartment, because it was obvious negligence. However, despite being interrupted by Vice Chair Carey, Tabitha managed to testify the same in paragraph 51 on page 46 of the transcript. So they do the bedbug spray, so there is 3 treatments, 2 sprays and an inspection, and if it's still live bed bugs, then they continue with a new cycle until they are cleared. She managed to testify one more time in paragraph 53 on page 47 of the transcript. And then if they find live bed bugs that day, then the next cycle starts the next following day. Tabitha Lantain testified 4 times that the landlord didn't treat every apartment in the building, but treated only a few units in it, where they found live parasites in the daytime. The landlord submitted to Justice Carey 7 one-page reports about treatments of the building in February-September 2011, and Tabitha Lantain testified that this set of 7 reports was complete for discussed period. Paragraph 47-48 on page 44 of the transcript. Ms. Odette, this is lawyer for TCHC, for the landlord. And so, aside from these documents that we have in this package, what other treatments completed on other units? Ms. Lantain, in general, usually, yeah. Ms. Odette, okay. Madam Chair, sorry, I think she is asking you, this is not a complete set of treatments from that building. Ms. Lantain, no, this is complete. Justice Carey reviewed these 7 reports from the landlord carefully. These 7 reports, each report was printed on 1 page, were the only documents submitted to Justice Carey except receipts from the petitioner. They are not complicated. Furthermore, their structure and content was explained to Justice Carey in details at the LTB hearing. According to the submitted reports, the landlord only treated for bed bugs 30 units in the heavily infested building in February-September 2018, 601, 626, and blah blah blah, all 30 units. Even without counting the treated units, just by looking at the reports, it becomes clear that number of treated units is small. There were no more submitted documents with other treated units. The fact that the landlord actually didn't bring to the board hearing all reports on the treatment of the building in February-September 2011 or 2018. Sorry for my false speech. Perpetrators interfere with it and do not let me speak properly. So, once again, the fact that the landlord actually didn't bring to the board hearing all reports on the treatment of the building in February-September 2018 doesn't change anything, since nobody even accidentally mentioned other treated apartments beside the above-mentioned units. There was no information at the LTB hearing that the missing reports could contain other treated units apart from these 30 flats. These 30 units were the only treated apartments submitted to Justice Carey at the board hearing. Nothing. First of all, we both testified, I and the opposite side, the defendant, testified that they treated only few units in this building, and after that they submitted, or before that, it doesn't matter, this hearing they submitted 7 reports that contained only 30 treated units. Description of the multi-story building and numeration of units, which was the same on each floor except the first, was explained to Vice Chair Carey as well. Justice Carey was informed and saw in the presented reports that the building is multi-story. There are 15 floors in it and the tenants where tenants live. She was informed and saw in the reports that there are 26 units on each floor, a bit less units on the first floor, so there are more than 370 units in the building in total. Therefore, TCHC actually treated for bedbugs 30 out of more than 370 units in February-September 2018. Sorry, once again, 2018. The board perfectly understood the treatment of only 30 units in February-September 2018 in the severely infested building, which demanded timely treatment of all units, was obvious negligence of the landlord. That was why Justice Ruth Carey invented in her ruling in favor of the landlord that every unit in the building was treated, and thus magically transformed 30 treated units into at least 370 treated apartments. So she multiplied actually 30 by 12 and got 370 treated apartments. These manipulations of evidences transformed slow, untimely, negligent and inefficient treatment of 30 units in the heavily infected building from February to September 2018 into timely and effective treatment of more than 370 apartments in February-July 2018. This misrepresentation and distortion of evidence by Justice Carey are errors of law and obvious bias in favor of the landlord. In summary, Justice Ruth Carey made her conclusion as if the petitioner failed to prove that the landlord didn't address the bedbug infestation in a timely and effective manner in paragraph 19 of her initial order. The tenant acknowledges that every time she complained to the landlord about a pest control issue, the landlord responded in a timely manner. Her complaint is that it wasn't effective because not all units were treated, but in fact, the landlord's evidence establishes that every unit was treated. The petitioner proved that both of the board arguments, so there were 2 of board arguments, and both of them were concocted by Justice Ruth Carey. So once again, the petitioner proved that both of these board arguments were invented by Justice Ruth Carey herself. Furthermore, they were opposite to all testimonies and evidence submitted at the hearing. It was a know-how of LTB to completely distort testimonies and submitted documents, concoct its own evidence, and then claim that this concocted evidence doesn't support a finding that it is more likely than not that the landlord failed to respond to the tenant complaint in an effective manner. Further, I wanted to discuss with you a decision of the divisional court, but it takes a lot of time. Of course, I just want to finish our conversation today because it took more than 45 minutes at this moment. So, in my opinion, from my experience, Justices Canada is a corporation of justices that can make every errors of law, can concoct and invent any arguments and base their conclusions, false conclusions, on these concocted arguments. Unfortunately, justices of appeal courts like Divisional Court, Court of Appeal for Ontario, Supreme Court of Canada, are corporation of justices that by all means support decisions of lower courts. So this is real justice in Canada. Again, this is not story that a justice didn't give enough attention or ignored solid evidence, no, and preferred unreasonable evidence, no, absolutely not. This is story how Justice Carey invented, concocted her own arguments that contradicted all testimonies and all submitted documentary evidence, and how she based her false conclusions on this concocted evidence, and how justices of appeal courts supported her. Of course, in this situation, all work of lawyers, law companies, law firms, and courts becomes absolutely useless, because it may be ignored at any moment by any justice, and this justice will never be responsible for his or her errors of law and wrongdoing. Thank you for your attention. Bye. And please spread the word. Thank you. Bye.